That's the reason I made it.
Why do you get a special day?
Every other day is a men's day.
Not Valentine's Day,
We have you on video.
I hate
second right now.
Valentine's Day, y'all can have that one. What?
not anniversaries.
Think about it, President's Day is
Not
a
their
male
birthday.
holiday because there's only male presidents.
Not March 14th.
Is that today?
Someone will figure it out in a minute.
Is that Father's Day?
No.
Oh my
Is it Steak and
God.
BJ Day?
I don't know what it
What is it?
Steak
I
and
know what
BJ
it
Day?
is.
I didn't say anything. I'm not on tape.
I'm gonna have to put that in my calendar. I know exactly what it is.
I think we'll be at AAJ then.
You know, is there a platinum plus nearby?
Oh, God. Okay. Your Honor, at this time, we would like to call Max Petunia to the stand. You're up, bud. I don't know what you're laughing at. Please introduce yourself to the jury.
My name is Max Petunia.
Where are you from?
I'm from right here in Steelton.
And what do you do for a living?
I am the owner of Max Petunia's Good Times, Montana Max's Good Times Saloon.
Is it okay if we call it Max's today?
Yes, of course, everyone does.
Can you tell us a little bit about Max's?
It's a local sports bar that we just have a bunch of food and drink, and people come in, and it's pretty much just directed towards college students.
What's the atmosphere like?
It's a great atmosphere. It's family friendly. We have a bunch of food and drinks, and then we also have games and prizes that people can win.
What kind of specials do you guys offer?
Well, our biggest special is Mexican Mondays, and on that day we have specials on 15 different food items, and then also 2 drink specials, and that's a really big hit with all the college students. They can come in a lot for that game, for that.
What kind of training do you have for your staff?
We have the TIPS training, which stands for Training for Intervention Procedures, and then we also have our policies that each employee is to follow while they're working with us.
Permission to approach, Your Honor?
Mm-hmm.
Max, what did I just hand you?
You handed us a section of our policies and procedures.
And what do you use these policies for?
These policies, in this policy in particular, is related to the service of alcohol.
How often do you do training sessions for these policies?
For these policies in particular, when a person is hired on, they follow around a veteran server, and they are trained in how to actually implement and use these policies while they're working with us.
How often do you have training sessions?
Related to these policies,
Yes.
all of our employees are trained in this. In the TIPS method, in the TIPS procedure, we have training every 6 months.
Okay. Now, before we get into these policies too much, I want to ask you what you observed about Al Overton on the night of the incident.
I observed him and a group of his friends come in. They indicated that it was his 21st birthday, so I directed additional staff to keep an eye out on them.
And what did they observe? What did you observe over the course of the night with Al?
I observed Al have a few drinks, and then he got into an argument with his group of friends, and that's when the night kind of changed.
Now, you said he got into an argument with his friends. What was that argument about?
His friends had he had been accused by his friends of groping one of the Miss Mischievous girls, one of our additional employees that we have, and that's when the argument broke out.
And what happened after the argument?
Al got boisterous and loud, and then we had to ask him to leave.
What did Al do when he left?
Objection, lack of personal knowledge. He doesn't know what Al did after he left.
If he knows, he knows. If he doesn't, he doesn't. So I'm going to overrule that.
What did you observe about Al as he was leaving?
I observed Al, he knocked over a tray, he held up his keys, and then he left.
Did he say where he was going?
He said he was going to Michigan Mike's.
Why didn't you call him a cab?
Oh, we don't call cabs for just any person that comes into the bar.
Who do you call cabs for normally?
We call cabs for intoxicated people.
And how did Al appear to you when he left?
He didn't appear intoxicated. He appeared very angry at his group of friends, but not intoxicated.
So now I want to talk a little bit about your policies and Al. What do your policies say about observing change in behavior?
It's a pretty big indicator to see if someone is intoxicated, is change in behavior.
What was going on in particular on the night of the incident? What was happening at the bar?
Oh, it was the BCS National Championship game. Like, everyone knew that this game was occurring that night.
How did that affect you using this observation of behavior that night?
Well, it wasn't as useful as any other night because every time a score happens, everyone starts cheering. Every time a fumble happens, everyone gets depressed. So it was just a roller coaster of emotion the entire night.
What happens to your employees if they don't follow these training methods?
Well, we have to let them go because we can't be serving alcohol in a improper way.
Now, you mentioned that Al was angry. What do your policies say about anger and intoxication?
With anger and intoxication, the person needs to be removed if they're starting to cause a scene and stuff like that. With intoxication, we try to make sure that they have a ride, get a cab, give them some food and water, or something along those lines.
What do your policies say about serving food to patrons?
When they're visibly intoxicated, we offer them some free food so that they have some time to relax before they leave.
Why didn't you offer Al free food?
Because he wasn't intoxicated.
What free food did you offer throughout the night, though?
Oh, it was Mexican Mondays, like I was saying earlier, and pretty much through the entire night, there's free chips and salsa throughout the sports bar.
Now, after you saw Al with the fight with his friends and the drink trays, what alcohol did you give him?
No, none.
No further questions, Your Honor.
Any cross-exam?
Yes, Your Honor. Permission to set up the courtroom, please.
Yes.
Now, Max, this incident with Al Overton occurred on one of your promotions called Mexican Mondays, didn't it?
Yes, it did.
And Mexican Mondays is where students can come in and get cheap drinks, among other things, right?
It's mainly the other things. It's mainly the 15 dishes that we have, the prizes, the games, and stuff like that. And we additionally have the discounted drinks.
And it was also the BCS National Championship football game, wasn't it?
Yes, it was.
And it'd be fair to say that your bar was crowded, wasn't it?
Yes, during the game it was particularly crowded.
So crowded, in fact, that it was almost 30 people over the fighter code limit, wasn't it?
Yes, during the game.
And to compensate for this, you had some shop servers working, who you call your Miss Mischievous girls, right?
Yes, we bring in additional staff when it's going to be a particularly busy night.
And speaking of shots, it was your understanding that when Al and his best friends came in, they were planning on taking 21 shots to celebrate Al's 21st birthday, correct?
Yes, that was my understanding, but we would never serve them that many shots. And once I understood what they were planning on doing, I added additional staff to watch out for them to make sure something like that would never happen.
Well, regardless of whether they took 21 shots, you personally observed Al drink several shots, didn't you?
I saw him drink 4 shots, yes.
Now, Max, I want to switch and talk to you a little bit about your training, because isn't it true that these shot servers aren't trained in your tips procedure?
These shot girls, they work on an infrequent basis. They come in, they come out, they work when we need them, they work when we don't, they go work other places. So on our consulting people that come come in every 6 months that train on the tips procedure, yes, some of those shot girls are not trained in that just because they're not there for that long. But they're definitely trained in our policies
Now,
before they start serving any alcohol.
however, tips is where your servers learn to identify visibly intoxicated persons, right?
That is a factor of tips, yes.
And how to determine if a patron is going to be driving, right?
That is another thing that is taught in tips, yes.
And Maxis tries to train its staff every 6 months, right?
In the tips procedure, but every employee that we have is trained in the policies and procedures of the bar. And they're not allowed to sell alcohol to intoxicated people. They follow these procedures. And yeah,
Max, if it had been 5 months since your last training session, your new servers would not be familiar with your tips program, would it?
yes, if they hadn't been through the procedure, they wouldn't be familiar with it.
And it's not your wait staff, your waiters and waitresses who are serving those shots, are they? Correct?
The bartenders can serve shots and shot girls can serve shots.
So Al and his buddies were getting shots from the untrained girls, right? Your Miss Mischievous girls.
They're trained in our policies. They're untrained in the tips method, and that's because they weren't there during the 6 months since the last training session.
And you have a rule for these shot girls to not sell more than one shot to the same customer, right?
Yes, that is correct.
But that does nothing to stop someone like Al and his buddies from getting a shot from each of the shop girls working that night, does it?
That is a possibility.
And Max, aside from your estimate, you have no exact way of knowing how many shots, how many drinks Al had that night, do you?
I don't have an exact way of knowing, but I saw him have 4 shots, and that's when the argument with his friends broke out, and we had to ask him to leave because he was arguing.
So you have no way of knowing, even though your policies and procedures state require you and your staff to always count the number of drinks served to your patrons, correct?
Our policies and procedures does say that, and we try to follow that as well as we possibly can, but that's not the law.
This can easily be done by using bar tab receipts, can't it?
That is a possible way of doing that, yes.
But you never saw a receipt for how many drinks Al had that night, did you?
I'm the owner of the bar, I don't actually serve the drinks.
So you don't know how many drinks he had, do you?
No, because I'm the owner of the bar, I don't actually serve the drinks.
But you personally observed him have at least 4 shots in a beer, didn't you?
Yes, like we discussed earlier, I heard them come in, and I heard them talking about trying to take an excessive number of shots, so I started paying particular attention to this group of people.
And it's possible that Al could have gotten more shots that you didn't see, isn't it?
I guess it's possible, but
Because your restaurant was a roller coaster of emotions, I believe is what you just said in your deposition. You couldn't observe your
Objection.
guest
This is
well,
a-
correct?
I believe this is an improper attempted impeachment.
Not attempting to impeach at all. I was
Then this
reiterating what he said during his.
Then this is outside of the scope of direct because that was not said on direct.
Overruled as far as that goes, and I'll overrule it's cross-exam, she can cross on that.
So, and it's also possible that Al's buddies could have given them some of his shots as well for his 21st birthday, right? Or some of their shots for his 21st birthday, right?
I guess it's possible.
Now, your policies and procedures, they also state that observation of behavior is one of the best indicators of intoxication, correct?
Yes, it does.
And you'd agree with me that Al becoming loud and fighting with his friends in a crowded bar is a change in behavior, right?
It's a change in behavior, but I was observing Al, and he wasn't intoxicated, so it doesn't fall into the category of 7.4.
And Al, you'd agree with me that Al screaming and arguing with your bouncer would be loud and rude, correct?
It was both loud and rude, but again, Al intoxicated, so it doesn't fall under the 7.4 categories of our policies and procedures.
Now, Mr. Petunia, you'd also agree with me that impaired motor coordination is one of the most obvious signs of intoxication, correct?
Of course.
And that would include things like stumbling, tripping, and spilling drinks, right?
Those are signs of intoxication, yes.
And it's true that Al spilled multiple trays of drinks while in your bar, isn't it?
I think the better way to characterize it is he intentionally knocked over a bunch of drinks in his anger.
And even though it's not in your policies, Mr. Petunia, you'd agree with me that vomiting is a major sign of intoxication, wouldn't you?
I presume so.
And it's true that Al Overton vomited in your bar.
That is true.
Now, after vomiting, fighting with his friends, and knocking over trays of drinks, Al left your bar, didn't he?
Yes, we asked him to leave because of the fighting incident. Again, he wasn't intoxicated. Our policies and procedures related to alcohol didn't kick in because he wasn't intoxicated.
After all that erratic behavior, he was yelling at your bouncer, screaming insults at your bar, held up his keys, and said he was going to another bar, right?
Yes, again, I observed Al and his behavior that night. He wasn't intoxicated, so we asked him to leave.
No further questions.
Any redirect?
Yes, Your Honor, excuse me. What do your policies and procedures say about using them? Are they guidelines?
Yes, they are guidelines.
Now, I would like to turn your attention to what opposing counsel was talking about with impaired motor coordination. What else does it say that you should observe?
The person's
Objection,
behavior.
mischaracterization of the policies and procedures do not say they're a guideline, only the BAC part says it's a guideline.
Overruled.
Do you have the copy?
Yes.
I just want to make sure you can see it.
What was the question?
What does it say about, what else does it say about observing impaired motor coordination?
To not serve any additional alcohol.
What does it say about slurred speech?
That it's a sign of intoxication.
What did you observe about Al's speech that night?
He didn't have any slurred speech at all.
How many times did you see Al stumble?
I didn't see him stumble at all.
How many times did you see him spill drinks?
I saw him intentionally knock over a tray, but I didn't see him stumble and trip over a tray or anything like that.
Okay, thank you. No further questions.
All right. Witness may step down. Does the defense have any witnesses it wishes to call?
Motion to reprove our demonstrator.
Yes.
At this time, the defense would call Dr. Gene Malkin to the stand.
Okay.
Your Honor, request just a brief minute to set up the courtroom with demonstrators.
Certainly.
We need that.
You do? Okay.
Take the court's soldiers, Your Honor. Dr. Malkin, would you please introduce yourself to the jury?
Hi, my name is Dr. Jean Malkin.
Where are you from, Dr. Malkin?
I live here in Steelton. I went to school at Steelton State both for undergrad and my graduate degree, and honestly I couldn't leave after I fell in love with it.
You mentioned your degrees. What type of education do you have?
Well, I double majored in undergrad in pharmacy and hospitality, And then I continued to get my master's in toxicology, and finally I got my PhD at Steelton State in pharmaceutical chemistry in 2000.
And what do you do for a living now, doctor?
I'm a consultant in the fields of toxicology and something else.
Would it be the service of alcohol?
Service of alcohol, that's it.
And what type of businesses employ you to do this work?
I work for a lot of national organizations that are in the hospitality industry, consulting them on how the body chemically reacts to alcohol in its system, how it processes the alcohol in the system, and responsible practices if a hospitality industry is going to serve alcohol to individuals that come to visit.
Specifically, what businesses employ you to do this work?
Well, currently I work for Buffalo Wild Wings. It's a national chain of bars and restaurants. I travel to all their different locations across the U.S. to train their employees on these proper practices and procedures of serving alcohol.
How long have you been with Buffalo Wild?
Since 2013, so just about 3 years now.
Have you worked for any other businesses?
Yes, prior to Buffalo Wild Wings, I worked for a national hotel chain called the Westin Hotels, and I was there doing the similar consulting work on alcohol service, and I spent my majority of my career there, about 14 years.
And why are you here today, Dr. Malkin?
I'm here today to give an opinion about the service of alcohol that Montana Max's provided to Al Overton on the night of the 7th going into the 8th.
And what materials have you reviewed?
I've reviewed all the depositions in today's case. I've reviewed the policies and procedures manual for Montana Max's, and as well as all the social media pages and other documents that were provided to me, however, did not play as much of a role.
And what type of methods did you apply to your review of the case?
I reviewed the depositions for the factual content of the incident that night, and then I took that and compared it with the policies and procedures and the industry standard to come up with a determination and a conclusion,
Did you
or
say
an
these are,
opinion.
excuse me, doctor, I didn't mean to cut you off there. Would you say these are reliable principles and methods in your field?
Oh, absolutely.
And doctor, you stated you were contacted to form an opinion without telling me, have you formed an opinion in this case?
I have formed one.
Your Honor, at this time we will tender Dr. Malkin as an expert in the field of hospitality and service of alcohol.
Any objection?
No objection, Your Honor. We had stipulated to your expertise earlier.
Okay. Then without objection, she will be entered as an expert.
Thank you, Your Honor. Dr. Malkin, you stated you formed an opinion in this case. What are those opinions?
I came to two major opinions. The first opinion that I reached was that it was impossible for Al Overton to have a BAC level that would have indicated any signs of intoxication to the Montana Max's employees. In addition to that opinion, I found that Montana Max's employees implemented proper training policies and procedure in their service of alcohol.
Let's talk about the training policies. What training does Montana Max's use?
Montana Max uses the TIPS training.
And what does that stand for, TIPS?
TIPS is an acronym for Training Intervention Procedures. So it basically means we are training the hospitality employees to intervene when intoxicated patrons become a problem at the establishment.
And how often were the employees trained in this method?
At Montana Max's, they had a standard policy of training every 6 months.
And who did this training?
There were nationally certified TIPS trainers who were brought in and paid for to come and give a whole day training where they closed down the store and everything.
Which employees were trained in this TIPS training team?
All the employees that were employed at the time that the training was going on would have to attend that training. So any employees that were employed at that time would have to attend the training.
And what's your opinion about this training, the level of adequacy?
I found that the TIPS training is not only a sufficient training method to use in the hospitality industry, but the time frame in which Max implemented the training of every 6 months was absolutely sufficient to train the employees adequately.
Now, we've heard testimony here today that some of the employees were not trained in tips. What opinions do you have about that?
Since there was training methods for every 6 months, there is the possibility that some employees were not trained in the TIPS method. However, on the night of the 7th to the 8th, I didn't find this to be a problem since the Montana Maxis was actually overstaffed, so there was plenty of overlap from the employees. Further, all the employees were trained on the policy manual that Montana Maxis implements, and this is the information contained in the policies directly comes out of the TIPS technique and training.
Now, doctor, I want to move to your other opinion, that if it's chemically impossible that Al Overton was visibly intoxicated. How did you come to that opinion?
I reviewed a nationally recognized chart on BAC levels and took into consideration the time frame, the weight of Al Overton, and the numbers of drinks that he consumed on the night of the 7th going into the 8th.
And what were you able to determine using this information?
I was able to calculate Al Overton's BAC, and his BAC was around a 0.06 to 0.07 at the time he was at Montana Maxis.
And why is that significant?
It's significant because a level of blood alcohol concentration that would show visible signs of intoxication, well, that's a 0.15, which would mean which is double what Al Overton had experienced a blood alcohol level on the night in question.
Would you be able to explain your calculations in coming to this conclusion to the jury?
Yes. I could use a whiteboard to assist me.
That would be helpful. Would you also like a copy of that chart?
That would be great.
Beg of course indulgence for a moment, Your Honor. Had to mix up with our evenings. Won't happen again. Your Honor, I'll ask permission to display a demonstrative. This is the chart from Montana Max's policies and procedures. It's already been entered in that.
Perfect.
Dr. Malkin, can you tell us, what are we looking at here on the jury's left-hand side?
Well, this is the chart. It comes directly from the Montana Max's policies and procedures. It's nationally recognized to calculate a blood alcohol concentration by taking into consideration the two main factors, drinks that are consumed and the body weight of the person consuming those drinks.
And how much did Al Overton weigh on the night of the accident?
Al Overton, since the night of the accident, has lost significant weight, but on the night of the accident, Al Overton weighed 225 pounds.
Dr. Malkin, based on your review of the case, how many drinks did Al Overton have while he was at Montana?
Based on Al Overton's own deposition, Al says that he took 5 to 6 shots on the night in question.
Sorry.
Al also says that he nursed a beer throughout the night.
So, how many drinks did he have?
Well, this would look like he had about 5 to 7 drinks, or I'm sorry, 6 to 7 drinks. But when actually doing the calculations for this chart, we have to take into consideration the absorption rate of alcohol through a time frame.
What do you mean by that, the absorption rate of alcohol?
Well, you see, our liver is naturally processed to eliminate an alcoholic beverage every hour. So that means that basically our liver completely discards one alcoholic beverage for every hour. So since Al Overton was drinking over a 1.5 to 2 hour period, we have to eliminate 2 drinks from this count to accommodate for the liver's removal of the alcohol.
based on these calculations, what did you determine on this chart?
Now we have to plug in the two numbers we have here, the weight and the number of drinks consumed. Since Al Overton's exact weight does not appear on the chart, we have to take into consideration the two columns of 220 and 240. And since worst case scenario, Al consumed 5 drinks, we'll look at the greater of 5. When we bring the two columns together, we find that Al's BAC level was between a 0.07 and a 0.06.
All right, Dr. Malkin, when did Al Overton begin drinking that night?
Well, that's a good question. BAC can be affected through a time frame, so we have to look at the whole timeline. And I'm going to start one down here at the bottom, tracking Al's BAC and the time. We know that at 12 o'clock midnight, since Al was celebrating his 21st birthday, he had nothing to drink prior to that. So his BAC started at 12 o'clock at a 0.00.
All right, and how long was he at the bar that night?
Again, we talked about how Al Overton spent about an hour and a half to 2 hours at the bar.
And what time did the accident happen?
The accident occurred around 2:30 in the morning.
Was Al Overton ever given a breathalyzer after the accident?
Al Overton was given a breathalyzer. This breathalyzer was taken almost an hour after the accident, about an hour after the accident.
What was his BAC at that time?
Al Overton's BAC at 3:30 in the morning was 0.12.
Doctor, just so we're clear, what was his BAC when he left Montana Max's that night?
That would be at this point, and his BAC, as indicated by the chart here, was between 0.06 and 0.07.
Dr. Malkin, what can explain the discrepancy between a 0.07 and a 0.12? That's a pretty big leap, isn't it?
It's a very large leap, and the only explanation is for there to have been more alcohol consumption between this point and the point in which Al Overton blew a 0.12.
What evidence of alcohol consumption did you review in this case?
Well, obviously I viewed the alcohol consumption that occurred while at Montana Max's. However, there's limited information during these time frames prior to the accident and prior to Al receiving the breathalyzer. However, there is some evidence to say that a half bottle of liquor was found in Al Overton's vehicle at the time of the accident.
And what kind of bottle was that?
It was a Bad Dog bottle of liquor, malt liquor,
Do you know,
with an alcohol concentration of 15%.
and do you know what color Bad Dog liquor is?
Yes, this liquor was purple in color.
And what color, was there any evidence of the Bad Dog liquor on Al Overton that night?
When Al Overton was arrested, he was arrested with a purple stain on his shirt.
Thank you, Doctor. You can return to the stand. Doctor, last question for you. What is the blood alcohol content level where a person will display visible signs of intoxication?
That would be a 0.15.
Your Honor, at this time, we ask to preserve both of these demonstratives for use at closing argument, and I have no further questions from Dr. Malkin at this time.
Okay, any cross-exam?
Yes, Your Honor. You said that Al Overton was likely drinking Bad Dog liquor in his car,
Absolutely.
but you failed to mention Bad Dog liquor at all in your opinion that you provided to the court.
My opinion was to observe Montana Max's policies and
The bad dog liquor was something that occurred after Al Overton had left Montana Max's.
But you did talk about how his BAC, he registered a .12 when he was breathalyzed.
Yes,
And you
correct.
said that because he might have had food in his stomach, it wouldn't have peaked until after the accident.
The blood alcohol concentration absorption rate could be affected by food, yes.
So you did talk about his blood alcohol level after he left Montana Max's.
The blood alcohol level I came to a conclusion about was when Al left Montana Max's, which is indicated on the timeline.
But even when you made that calculation, you didn't factor in the bad dog.
No, because Al hadn't consumed the bad dog yet. That
Okay.
was after he left the bar.
Okay, and you say that you wouldn't have shown visible signs of intoxication until you hit .15.
Correct.
So here it would be, for him, it would be around 10 drinks.
Correct.
Not including the 2 hours he was there, which would remove 2 more drinks.
This calculation already takes into consideration a removal of a drink, so yes.
Okay, but, so it's your testimony that Al, even though he had only drank 1 or 2 times, would have to have 11 or 12 drinks before exhibiting physical signs of intoxication?
Yes.
But BAC is not the only indication of visible intoxication, is it?
No, it's not.
You also want to look to the physical signs someone's exhibiting,
Absolutely.
which is actually what the policy say is the best thing to do.
It's one of the best things, yes.
You want to look at signs like spilling drinks,
This could be an indication, but not always.
becoming rude,
Also could be an indication, but not always.
vomiting.
I don't believe it specifically discusses vomiting, but obviously you could be sick from alcohol, so you could vomit.
And Al was exhibiting all 3 of these signs of intoxication.
He was exhibiting them, but not due to intoxication.
But the only evidence that you came across during your investigation that would indicate he had eaten bad food was from Max Petunia's deposition, right?
Yes, Max Petunia was told that Al Overton had consumed some bad food, which I'm sure Max wasn't pleased about since he probably ate at his restaurant, and that's the reason for the vomiting.
But Max didn't hear this from Al Overton, did he?
I don't believe so. I believe the waitress came to inform Max of that.
So Max heard it from a waitress who had overheard it from Al.
I'm sure Al was complaining about it to the waitress, and the waitress was informing her employer of the bad food.
Okay, and when you so you're saying that when Al threw up, it wasn't a sign, or the Montana Max, the defendant, shouldn't have investigated further.
No, it was due to bad food. Al said it himself.
And when he started getting in arguments with his friends, you don't think that Montana Max should have investigated further?
No, Al was actually standing up for the shop girls and was yelling at his friends for being rude and not polite.
And when he was leaving and waving his keys over his head, saying that Max is a shitty excuse for a bar, you don't think that maybe he should have inquired to see whether he had a ride or whether he was indeed drunk?
He knew he wasn't drunk, so he didn't have to inquire.
No further questions.
All right, any redirect?
Very briefly, Your Honor. Dr. Malkin, on cross-examination, you testified that food can play a factor in this range. How much of a factor does that play?
Food doesn't play much of a factor, if at all, in the actual BAC number. The only thing food plays a factor in is the time of absorption to reach a BAC level, such as 0.06 to 0.07.
All right, thank you. At this time, we have no further questions, Your Honor. We do have Plaintiff's Exhibit D. I believe it's been set on the jury roll. Where would you like that in?
Place it up here on the corner.
Thank you, Your Honor. Register to approach the place.
Yes.
No further questions. Your
Okay.
Honor.
Witness may step down. Does the defense have any other witnesses it wishes to call?
No further witnesses at this time.
All right, any other motions or anything we need to take up?
I would see, so we review our motion for
Okay. Anything has changed from earlier?
They still have not proven that Al had anything to drink, if he was visibly intoxicated, which goes to show negligence, so they failed to meet their burden on that.
Okay.
We renew our comments from earlier. Also, they're just arguing negligence per se. We've already dropped our negligence per se argument and are proceeding solely on negligence.
All right, I'm gonna deny those motions. Ready for closing?
Yes, Your Honor.
All right.
Your Honor, Brett, can I eat while he's
Yep,
doing
that's fine.
drinks?
Members of the jury, there's an old story about a man who opened up a store right in the middle of town. And in order to get customers in the door, he decided he was going to get a lion as an attraction to get people in there to see what he was selling. So he got the lion, and he got a cage for the lion, and it worked. People started coming in, and business was good. But one day, the lion got out, and it killed someone. And when townspeople came to the store owner, blaming him for what the lion did, the store owner said, I did all I could do. I had the lion in a cage just like any reasonable person would have done. But that doesn't matter. The law says that if you bring a lion into town, if it gets out, that's your responsibility. And if it hurts someone, you're liable. And while we're not accusing the defendant of bringing a lion into his bar, he did something that's arguably even worse, even more dangerous. He brought in college-age kids, he packed them into his restaurant and selling cheap alcohol. And as you heard over the course of this trial, one of those kids got loose and slammed into the side of Quinn Chase. Responsibility, reasonability, liability. It was the defendant's responsibility to take reasonable measures to prevent injuries to his patrons and the community. And because Max failed to act reasonably, Al Overton was served to the point of visible intoxication and allowed to stumble out the front door, get in his car, drive away, and slam into the side of Quinn Chase's car. And for that, Max has liability. Members of the jury, on the night of January 7th and into the early morning hours of January 8th, Montana Max's Good Time Saloon was the place to be. The national championship game was on, it was Mexican Monday, the drinks were cheap, and the shop girls were out to make sure everybody had enough booze. And that night, Montana Max's was nearly 30 people over maximum capacity. And into this madness walks Al Overton, there to celebrate his 21st birthday, there to take shots, and there to get drunk. Today, you learned that it was the defendant's responsibility to make sure that there weren't too many people in the bar. It was their responsibility to make sure all of their employees were properly trained. And it was their responsibility to make sure a visibly intoxicated person was not allowed to drive away. It was their responsibility to act reasonably. But what happened instead? Instead, you heard that Al Overton was permitted to stay, even when his friends showed up bragging about how he was going to take 21 shots for his 21st birthday. Instead, you heard that the defendant did not train all of the shop girls properly, and instead only trained them twice a year. Instead, you heard that Al got shots from these untrained shop girls. The defendant witnessed him drink some of these shots, and then Al subsequently got into an argument with his friends, knocked over tray drinks, and vomited. And what did the defendant do? He didn't call Al a cab like his policies say to do. He didn't prevent him from leaving like his policies say to do. No, not only did they not prevent him from leaving, they kicked him out. They made him leave. What is that what a reasonably careful bar owner would have done after seeing Al doing all of that inside of his bar? After we finish with closing arguments, the judge is going to tell you that you must decide whether the defendant was negligent or not. And when he does, that is the question you need to ask yourself. Did the defendant act in a reasonably careful manner to avoid injuries? Would a reasonably careful person act the same way that the defendant acted that night? Ladies and gentlemen, when you answer no to that question, you must find that the defendant is negligent and that the defendant is liable. Today we heard from Sydney Crosby, an expert in the service of alcohol, in hospitality and the service of alcohol. She explained to you why the defendant's actions that night were unreasonable. When Al and his friends showed up saying that they were going to take 21 shots for his 21st birthday, they should have immediately told him to leave, because no one can safely drink that much. And because the bar was so crowded, there's no way that the employees could properly monitor every single customer. So if you know that someone's trying to attempt something that's dangerous, something that puts other people at risk, you should immediately make sure that that person leaves and not serve them any alcohol at all. Would a reasonable bar let untrained... So you also heard that Max's shop girls, or mischievous girls as they like to call them, weren't all properly trained. They let these girls serve shots of liquor to the consuming public without even requiring that they complete an alcohol training safety course by certified instructors. And while the defendant claims that there was enough overlap between employees who were properly trained and those who weren't to make things safe enough, it doesn't make up for the fact that they weren't properly trained by certified instructors. The defendant brought in certified instructors twice a year for some of the employees, but why not make sure that everyone is trained by these instructors? Would a reasonable bar let untrained girls serve shots of liquor to guests without first teaching them how to spot signs of intoxication or prevent alcohol-related accidents? Absolutely not. A reasonable bar owner would have made sure that everybody was properly trained. Ms. Crosby also told you that a reasonable bar owner would have prevented a visibly intoxicated patron from leaving that night. The defendant's own policies say that as well. And while the defendant claimed that Al didn't look intoxicated to him, he did admit that Al and his friends were going to take 21 shots of liquor. That he saw Al drink some of these shots and then throw up and tip over a tray of drinks and get into a fight with his friends. According to the defendant's own policies, this kind of change in behavior is one of the best indicators of intoxication. And it says that the most obvious tells of an intoxicated person are stumbling, tripping, spilling drinks. The change in behavior, stumbling, spilling drinks, right there are 3 telltale signs that, according to the defendant's own policies, would indicate that someone is visibly intoxicated. And still, no one at Max's asked one of Al's friends to take him home, like the policies say to do. No one offered Al free food or non-alcoholic beverages, like the policies say to do. No one prevented a visibly intoxicated Al Overton from leaving the premises of Montana Max's Good Time Saloon, like their very policies say to do. And what's even more astonishing is that the defendant either knew, or should have known, that when Al stumbled out of the front door of Montana Max's, that he was going to get into his car and drive away. The defendant admitted that he saw Al waving his keys in the air as he left, but said that he didn't know what he meant by that. Ladies and gentlemen, use your common sense. When someone's waving their keys above their head and walking out, it doesn't mean I have a ride home. It doesn't mean I'm walking home. You know what it means. And while the defendant maintains that Al said he was getting a ride, you heard from the deposition of Al Overton that when he dangled his keys over his head, he said he was going to Michigan Mike's, with no mention of getting a ride. Would a reasonable bar owner kick a visibly intoxicated patron out of his bar knowing that that patron was going to be driving? No. But let's say that he didn't know for a fact that Al was going to be driving. Wouldn't a reasonable bar owner, at the very least, have asked if he was getting a ride, or watched as he walked into the parking lot to see if he was going to get behind the wheel of a car? That's not on their policies, but violating their policies isn't the only standard that we judge the defendant by today. In this case, you must decide whether the defendant was negligent. And after closing arguments, the judge is going to tell you that that means that the defendant failed to act the way a reasonably careful person would have acted in order to avoid injuring others. And as the plaintiff, it is our burden to prove the elements of our claim by the preponderance of the evidence. And when you're looking at the evidence again during deliberations, keep in mind just exactly what a preponderance of the evidence is. It's not the same thing as beyond a reasonable doubt, which you may have heard on TV or in the news. That's what the standard is in a criminal trial, and that is a very, very high standard. In cases like this, civil cases, the standard's not so high. A preponderance of the evidence simply means that something is more likely than not. If you were to think of an old style of a scale with the pans on either side, the scales just have to tip slightly in our favor. It just has to be 51% more likely that the defendant failed to act like a reasonable person would have acted. So to succeed on our claim, we must prove that it is more likely than not that a reasonably careful person would have told Al and his friends to leave upon hearing that he wanted to take 21 shots. That it's more likely than not that a reasonably careful bar owner would have trained all of their employees and had them trained by certified instructors. And that it's more likely than not that a reasonably careful bar owner would make sure that a visibly intoxicated Al Overton was not allowed to get behind the wheel of a car. So when you go back to deliberate and you're given a verdict form, so when you go back to deliberate, you're going to be given a verdict form. The first question that form's going to ask you is, was the defendant negligent? Ladies and gentlemen, you've seen the evidence. A reasonable bar owner would have asked them to leave upon hearing that they were going to take 21 shots, would have trained all their employees, and would have made sure that a visibly intoxicated person didn't drive that night. And because the defendant didn't, you should check yes for question 1. The second question is, was the negligence of the defendant a factual cause of any harm to Quinn Chase? This means that the accident wouldn't have happened but for their negligence. So when you're thinking about this question, you need to ask yourself, if the crash would have happened if they immediately told his friends to leave, would the crash have happened if everyone was properly trained? Would the crash have happened if when I was leaving, Montana Max had called him a cab instead? You heard from Al's deposition that when he was leaving Montana Max's parking lot, he stopped at a red light. He looked both ways. When he proceeded to make a right-hand turn on the red light, boom! Quinn Chase's car came out of nowhere. If you're sober, does a car come out of nowhere if it's only going 30 miles per hour? It doesn't, and that's why you should check that out. Ladies and gentlemen, a car going 30 miles per hour doesn't just come out of nowhere if you're sober. And because of that, you should answer yes to question 2. The third question asked was Quinn Chase negligent? Ladies and gentlemen, there's simply no evidence that Quinn Chase acted unreasonably that night. He was sober, he was driving under the speed limit, and he had a green light at the time of the accident. That's why you should check no for question number 3. And if you do, there's no need to even answer question number 4. But let's talk about question 4 briefly. It asks, was Quinn Chase's negligence a factual cause of any harm to Quinn Chase? So even if for some reason you were to find evidence of Quinn Chase being negligent that night, he was T-boned while he was going for a green light. There's nothing that he may have done or been doing that night that could contribute to him being T-boned. He was going for a green light, and he was driving under the speed limit. And that 5th question asks you to attribute a percentage of harm to Quinn Chase of Petunia Enterprises. And here, since there's nothing to indicate that Quinn Chase did anything wrong that night, I put a 0 right next to his name, and 100 next to the defendant's. You see, ladies and gentlemen, it was the defendant's responsibility to make sure that their actions didn't cause harm to the community. And it was the defendant who was to act like a reasonably careful person. But instead of training everyone in alcohol safety before letting them serve alcohol to the public, they only train their employees twice a year. Instead of asking customers to leave that they knew were dangerous, they kept serving them alcohol. And instead of preventing a visibly intoxicated person from leaving, they kicked him out, let him get in his car and drive away. Instead of making every effort to help Al Overton, all the defendant and his expert did was make excuses for his behavior. So when you're finished deliberating, you come back in here to render your verdict, tell the defendant, just like the man with the lion, it was your drug customer that got loose. It's your fault, and you must pay the consequences. It was your responsibility. You should have acted reasonably, and because you didn't, it is your liability. Find the defendant 100% liable. Thank you.
Defense?
Yes, Your Honor. Again, just a brief moment to set up the court.
Yeah, but whenever you said that we were gonna figure it out after, because I tried to set up during mid-trial and it wasn't right. It's okay.
Please court, Your Honor.
You may proceed.
Members of the jury, at the very beginning of this trial, Ms. Blom stood right here, and she told you the plaintiff was going to present a case that asked you to believe this is all as easy as ABC. But they're able to convince you that it's all as easy as ABC because they have asked you to believe a case that is presented based on assumptions that are asking you to blame the defendant, Max Petunia, by jumping to conclusions. And hopefully now that you have seen all the evidence in this case and you have heard the testimony presented, you can see that this case is not as easy as ABC. Because the plaintiff has failed to meet their burden of proof. They have failed to prove to you that Al Overton was ever visibly intoxicated when he was inside Montana Max's. And furthermore, they have failed to prove to you that he was ever served any drinks after he was visibly intoxicated. Now, you had a chance to hear from Max Petunia here today. He sat right here on the stand, and he told you his story of fitness. And he told you that he knows how his employees are trained, and he knows they're trained properly. And Max knows what the law is. And Max knows that the law requires visible intoxication. And he told you, look, Al Overton was not visibly intoxicated that night. That's why he allowed him to leave. That's why he allowed him to leave with his keys in his hand. Because he wasn't visibly intoxicated. Max was watching Quinn Chase the entire night. Now, we talked about the law. What is the applicable law in this case? You see, the plaintiff has brought their claim under a general negligence theory. That means the question you must ask is, what would a reasonably prudent employee at a bar have done under similar circumstances? And I ask you, ladies and gentlemen, what would a reasonably prudent employee do? They would follow the law. The law that the Steelton legislature has set out for reasonable service of alcohol in a bar. This law that says visible intoxication is the that's the standard that you should apply in this negligence claim here today. And that means that in order for the plaintiff to prove their case, they have to present three things. That Al Overton was served, and that he was visibly intoxicated. That he was served after he was visibly intoxicated. And that serving him while visibly intoxicated was the actual and proximate cause of the damage that happened to Quinn Chase. And that is exactly what the plaintiff has failed to prove to you. Because you see, the plaintiff has the burden of proving these things, but they don't just have to prove them, they have to prove them by a particular standard. And that standard is a preponderance of evidence. That means that they have to prove each and every one of those elements is more likely than not. And they have failed to meet their burden. When you go back in that jury room, and you get to deliberate, and you get to review the facts of this case, I think that is exactly what you will find. And when you go back in that jury room, members of the jury, you will get to take some things with you. You will get to take the evidence, the exhibits that the plaintiff has entered into evidence, one policy, one evidence, one exhibit, and you will have a verdict. And this is the form where you will write your final decision. The plaintiff has already showed it to you, and I've got my own enlarged copy too. And there are questions on this verdict form, as you see. And the first question, was Petunia Enterprises, Max Petunia, was he negligent? But to answer this question, members of the jury, you have to think about the facts that were presented in the form of testimony here today. And you have to think about the evidence that you didn't hear today. In order to understand all this, I think it's helpful for you to see a time, to understand all the facts that are undisputed. You see, we know Al Overton did not begin drinking before 12 o'clock. We know that he was at Montana Max's until 1:30 or 2 o'clock. So those are the first points on our time. Now we also know that at 2 o'clock, Al Overton was escorted out by the bouncers. And we know that the accident happened around 2:30. This timeline means that if the plaintiff is going to prove their case, they must prove it within this hour and a half to 2 hour window right here. And how many witnesses did they present to you that were actually at Montana Max's during this time? Absolutely none. They brought you Quinn Chase, put him on the stand, but where was Quinn during this time period? Quinn was at his house with 100 of his closest friends drinking keg beer. They put Sidney Crosby up on the stand. Where was Sidney Crosby during this time period that Al Overton was being served? Was he there watching? No. Sidney Crosby was at Michigan Mike's, down the street where he's employed. Sidney Crosby wasn't there during this time. And let's talk about Sidney Crosby's testimony. What are the facts that Sidney Crosby actually told you? Sidney Crosby actually agrees to all the same facts that our expert, Dr. Gene Malkin, agrees to. Doesn't dispute the number of drinks he had, doesn't dispute the time period that he was at the bar, and he doesn't dispute Al Overton's weight. But Sidney Crosby and Gene Malkin come to different conclusions based on the same numbers. And how could that be? Because Sidney Crosby didn't do the calculation. Because Sidney Crosby has something to gain by his testimony here today. You see, he gave you that great language about how he's a salaried employee, but I guarantee you,
when his boss finds out about the testimony he gave in this courtroom here today, he might be awfully pleased, because he even admits that Montana Maxes and Michigan Lights are direct competitors. And therefore, he's a biased witness and has something. Now, we brought you an eyewitness in the form of Max Platoon, and he told you he was watching during this entire time. You heard that testimony. And we also brought you Dr. Gene Malton, who talked about the standard for visible intoxication. It's 0.15, all the way down at the bottom of this chart. Dr. Malton told you there is absolutely no way that Al Overton was visibly intoxicated during the time that he was at Montana Maxes. And therefore, based on all of the evidence that the plaintiff has failed to present to you, and all of the evidence that we have presented to you, members of the jury, for this first question, you must check no. And this form tells you that if you check no to that question, then Quinn Chase cannot recover. You shouldn't answer any more questions on this verdict form, because this case is over. But members of the jury, there are more questions on this verdict form, and you've heard it. And even if you go to question number 2, the question that asks, was the negligence of Petunia Enterprises, Max Petunia, the factual cause of the harm to Quinn Chase? The factual cause. What does that mean? That means that on this chain of events, we must know for certain that each and everything that happened during this time period is linked to Max Petunia's service of alcohol to Al Overton. And the only problem with that is that there are unknowns on this timeline. Dr. Malkin talked to you about these unknowns. We know it was around a .07 BAC when Al Overton left Montana Maxes. We don't know what he was doing for an hour or 30 minutes sitting in his car. And we don't know what his BAC was at the time of the accident. But we do know it was significantly higher after the accident happened. And what is the one thing that explains these unknowns? The empty bottle of Bad Dog liquor that was found in Al Overton's car. The purple-colored Bad Dog liquor, the same color purple that was on Al Overton's shirt. These are not actions of Petunia Enterprises. These are not actions of Max's employees. And that is the first break in our causal chain. But Al Overton wasn't the only one taking actions outside of Montana Max's that time. Because you see, members of the jury, 5 hours before Al Overton ever began drinking, at 7 o'clock, Quinn Chase tapped the can. And at the time the accident happened, at 2:30, Quinn Chase had been drinking for over 7 hours. And you heard Miss Barham ask him how many drinks he had on the stand. Couldn't even tell you the number. Because unlike Al Overton, who was being watched by Max Petunia and his staff for the 2 hours that he was there, nobody was watching Quinn Chase during this time. We don't know for sure how many drinks he had. And we don't know what his BSC was. And what effects that had throughout the night. And that is the second link in this causal chain. And because there are so many links in this causal chain, when you ask, was it a factual cause? Was the negligence of Max Petunia a factual cause? Again, we must check no to that answer. And the verdict form will tell you, if you check no again, then Quinn Chase cannot recover. You don't have to answer any more questions on this verdict. So members of the jury, as you can see,
this case is not as simple as the plaintiff would have you believe. There are a lot of moving pieces going on in this case. You got a lot of characters, and we have a lot of breaks in the chain. And what is the only thing that can explain the breaks in this chain? You can't explain it with assumptions. You can't explain it by placing blame where it doesn't belong. And you can't explain it by jumping to conclusions. Members of the jury, the only thing that explains the break in these chains is the BAC. The blood alcohol content of Quinn Chase, that we will never know that because nobody was keeping tabs on. The blood alcohol content of Al Overton that shows you there is no way he was visibly intoxicated while he was at Montana Max. And the blood alcohol content that indicates to you the only verdict that you can render in this case. The verdict that says that Max Petunia and Petunia Enterprises is not liable. Thank you.
Rebuttal?
Yes, Your Honor. You just heard opposing counsel say that repeatedly that the defendant was watching Al Overton that entire night he was in the bar. When he was on the stand, you heard that he saw him take 3 to 4 drinks. And then their expert comes up and says he had 5 to 6 drinks. So somewhere along that way, I guess some drinks were being drunk that the defendant did see. And it's in their own policies. Their own policies say that as employees, they are the first line of defense to ensure that customers have a good time, but don't put themselves or other members of the community in danger. Well, what has the defendant done today? Today they tried to shift the blame from themselves to the plaintiff. Essentially, they want you to blame the victim in this case, Quinn Chase. And the defense tried to argue that Quinn Chase is liable because he had a few drinks over the course of 7 hours. Over the course of 7 hours, according to their own expert, would remove 7 drinks from your system. And because he answered a phone call on his hands-free Bluetooth system, he's liable. The only evidence we have of Quinn Chase's actions that night show that he was going 5 miles under the speed limit through a green light at the time of the accident. And they also talked about this can of Bad Dog in the car as evidence that Al Overton was drinking in his car. But you heard their expert say again, she didn't even put that in her opinion that she made for the court. The defense, they want you to think that while Al was inside of the bar, he was sober. And then when he went out into the parking lot is when he did all his drinking. They want you to think he was a saint when he was inside and a sinner in the parking lot. But you can't have it both ways, ladies and gentlemen. While the defense is trying to blame anybody but themselves, they called their expert, and you heard her make excuse after excuse after excuse. Al's throwing up, oh, well, one of the waitresses told Al that, told Max that Al said that his stomach hurt. Al's getting in fights. Well, it wasn't his fault. He was just mad at his friends because of what they were doing. He's tipping over trays of drinks inside of the bar. Oh, well, he was still just mad about what had happened earlier. Members of the jury, these excuses don't negate the fact that Al was displaying visible signs of intoxication, and Montana Max's did nothing to investigate further. Nothing to prevent Al from becoming intoxicated, nothing to prevent him from leaving that night. They didn't act responsibly, they didn't act reasonably, and because of that, you need to find them liable. Thank you.
The fact that you winked when you said the sinner and saints.
This is lying.